All names, places, and institutions are aliases used to protect privacy. Procedures and timelines reflect real-world law and forensics for immersion. The gallery benches in courtroom 4C smelled of old wood and floor wax, the kind of institutional scent that clings to clothing after hours of waiting. Outside, late afternoon sun slanted through tall windows, but inside the air felt dense, pressurized by anticipation. Attorney North sat at the defense table, manila folder open before her, fingers resting on the edge of a page she had memorized weeks ago. Across the aisle, representatives from the district attorney's office conferred in whispers, their voices a low hum beneath the bailiff's preparations. At the far end of the room, behind reinforced glass in the holding area, sat a man the state had called a monster for 30 years. His name was Rook. He was 62 now, hair gone to steel grey, shoulders curved in the way that decades behind bars carve into posture. Judge Keystone had not yet entered, but Rook's eyes tracked every small movement in the courtroom, the clerk arranging numbered exhibits on her desk, the stenographer adjusting her machine, North's fingers drumming once, twice against the folder. He had learned to measure time in courtroom minutes, in the weight of silence before a ruling, in the particular quality of air when outcomes hung in balance. This hearing was different from all the others. It carried a density, a gravity that the previous motions and appeals had not. On the table before North lay a single document, the certified laboratory report from Arcadia Forensic Laboratory, dated 3 weeks prior, bearing a conclusion that contradicted the very foundation of the case that had placed Rook in prison. The report had arrived after a 2-year legal battle to authorize advanced DNA testing on biological evidence that had sat sealed in storage since the original trial in 1995. North had read the findings aloud to Rook through scratched plexiglass in the prison visiting room, and he had not spoken for a full minute afterward, eyes fixed on a point beyond her shoulder. Then he had asked her to read it again, slowly, so he could understand every technical term. The paradox was stark and undeniable. The criminal justice system had proven Rook guilty beyond reasonable doubt 3 decades ago, built a case that 12 jurors found compelling, secured a conviction that appellate courts had upheld. 30 years later, forensic science said the system had been catastrophically wrong. The person who killed the victim had left biological evidence at the scene, and that person was definitively, scientifically, irrefutably not Rook. The question that had haunted him through 10,000 nights in a cell was finally approaching an answer. How had this happened? And could the truth, delayed by 3 decades, undo what the lie had built? The case had begun on a frozen February morning in the industrial quarter of Riverbend, a mid-sized city where warehouses crowded along freight rail lines and shift workers moved between buildings in the pre-dawn darkness. The victim, a 29-year-old machinist known in this account by the alias Ember, had been discovered by a co-worker at 6:47 a.m. in the break room of Granite Fabrication, a metalworking plant that operated around the clock. Ember had suffered blunt force trauma to the head and ligature strangulation. The scene was brutal: an overturned chair, a shattered thermos, blood spatter arcing across the adjacent wall in a pattern that forensic analysts would later map with careful precision. The medical examiner, alias Dr. Cove, placed time of death between 11 p.m. and 2:30 a.m., a window derived from core body temperature, rigor mortis progression, and ambient conditions in the unheated break room. Rook worked 3rd shift at Granite Fabrication, operating a precision lathe in the machining bay adjacent to the break room. He had clocked out at 11:12 p.m. that night, 8 minutes after his scheduled end of shift, a detail recorded by the plant's timekeeping system. Surveillance footage from the employee entrance captured him leaving, coat draped over one arm, metal lunch pail in his right hand, walking with the steady gait of a man completing another unremarkable workday. That footage would later be scrutinized frame by frame by investigators, enhanced and slowed, examined for signs of distress or urgency. It showed nothing unusual, just a man leaving work, pushing through the heavy door into the winter night, disappearing from the camera's fixed angle. Lead Detective Harbour, a 23-year veteran of the Riverbend Police Department, known for his methodical approach and high clearance rate, arrived at the scene at 7:30 a.m. He walked the break room with forensic analyst Juniper, photographing the overturned furniture, the blood evidence, the victim's position. Ember lay on her back near the vending machines, ligature marks visible as deep furrows around her neck, defensive wounds on her forearms. The weapon, some form of cord or cloth, was absent from the scene. No murder weapon recovered, no obvious point of forced entry, no sign of robbery or sexual assault. The motive was unclear. Harbour ordered a canvass of all employees present during third shift. 12 machinists, 3 maintenance workers, 1 supervisor. Most reported seeing nothing, hearing nothing unusual. The break room sat at the far end of the building, insulated from the main floor by concrete walls and the constant drone of machinery. Several workers mentioned that Ember often stayed late, sometimes past her shift, to complete paperwork or avoid traffic. No one reported conflict, no one mentioned arguments or threats, but one person offered something different. A maintenance worker known by the alias Cinder told Detective Harbour during an initial interview conducted 3 days after the body was discovered that he had seen Rook and Ember near the break room at approximately 10:45 p.m. on the night in question. Cinder described what he characterized as a tense conversation, voices raised enough to be audible over ambient noise, body language that suggested disagreement. He claimed he had observed this interaction while moving between sections of the plant to check on a malfunctioning air compressor. The exchange, he said, lasted less than a minute before he moved on, thinking nothing of it at the time, just workplace friction, the kind that flared and subsided in high-pressure industrial environments. When asked why he had not mentioned this observation immediately after Ember's body was discovered, Cinder explained that he had not connected the dots, had not considered a brief argument significant in the context of a murder. But by the time detectives formally interviewed him 72 hours into the investigation, his memory had sharpened considerably. He now recalled specific details: Rook pointing a finger toward Ember's chest, Ember taking a step backward, hands raised in a defensive or placating gesture. He remembered Rook saying something that sounded like, "You're going to regret this," or "You'll be sorry," though he could not recall Ember's response. The clarity of these details, emerging days after the fact, would later become a point of contention. Rook, when questioned by detectives in the first 48 hours, acknowledged that he had spoken briefly with Ember that evening. He characterized it as an unremarkable exchange, perhaps 20 seconds, about shift schedules or overtime distribution, topics that had been sources of minor friction among machinists in recent weeks. Ember had recently filed a formal grievance with plant management about overtime allocation, a complaint that named several machinists, including Rook, as receiving disproportionate hours. Rook admitted awareness of the grievance, but described the conversation with Ember as cordial, dismissing any suggestion of hostility. He said he had clocked out at his usual time, driven home to his apartment 15 minutes away, and spent the night alone. No one could corroborate his whereabouts after 11:12 p.m. The discrepancy between Rook's account, a brief, unremarkable conversation, and Cinder's evolving narrative of a heated argument, became the first pillar of the prosecution's case. Detective Harbour, feeling the pressure of media coverage and family demands for answers, focused on building out this conflict as motive. He re-interviewed Cinder twice more, each session producing incrementally more detail. By the third interview, Cinder described Rook's posture as aggressive, said Ember had looked frightened or upset, recalled that the exchange had occurred specifically near the break room entrance rather than somewhere more ambiguous in the plant. Each telling added texture, and Harbour documented it all. Physical evidence provided the second pillar, though it was far more ambiguous than the prosecution would later portray. Forensic analyst Juniper, working with the Granite County Crime Laboratory, processed the break room extensively. She recovered dozens of fingerprints from various surfaces: the thermos handle, the break room table, the vending machine buttons, the door frame. Many belonged to Ember. Several were smudged beyond identification. 2 partial latent prints lifted from the thermos handle matched Rook's known fingerprints, captured from his employee identification card application years earlier. Juniper's preliminary report noted that these prints were consistent with incidental contact. Employees routinely shared items in the break room, handled the same coffee thermos, touched the same surfaces throughout shifts. The prints carried no visible blood transfer, offered no indication of when they had been deposited relative to the crime. They proved only that at some point, Rook had touched the thermos, a fact no one disputed. Juniper also collected trace biological evidence: fibers adhering to Ember's work shirt, scrapings from beneath her fingernails where she had clawed at her attacker, swabs from the ligature marks on her neck where compression had occurred. In 1995, DNA analysis existed but remained expensive, time-consuming, and limited in sensitivity. The crime lab in Granite County operated under severe budget constraints, with a backlog measured in months. Lab supervisor Granite made the decision to prioritize cases involving sexual assault or large quantities of blood evidence, where DNA results would be most probative. The trace material from Ember's body was meticulously photographed, logged into the evidence management system, sealed in paper envelopes according to proper protocol, and placed in climate-controlled storage. But it was not tested. The decision was pragmatic, driven by resource scarcity and the apparent strength of the eyewitness account. The investigation would proceed on testimony and circumstantial evidence rather than biology. Detective Harbour, determined to close the case, pursued additional leads. He sought to establish motive beyond the workplace grievance, interviewing other machinists about Rook's temperament and relationships. The picture that emerged was mixed. Some described Rook as quiet, solitary, a man who kept to himself and focused on his work. One co-worker characterized him as intense about fairness, quick to call out perceived inequities in shift assignments or pay. Another mentioned that Rook had once argued heatedly with a supervisor over safety protocol, an argument that had resulted in a written warning years earlier. None described violence, none reported threats. But Harbour compiled these fragments into a portrait of a man capable of explosive anger when provoked. Then, 3 months into Rook's pre-trial detention at Riverbend Detention Center, a third pillar emerged: the jailhouse informant. Rook had been held without bail, deemed a flight risk and danger to the community. His cellmate for 6 weeks was a man known by the alias Flint, awaiting sentencing on multiple burglary convictions. Flint approached Prosecutor Slate, the assistant district attorney assigned to the Ember case, through his own defense attorney. Flint claimed that Rook had confessed to the killing during late-night conversations in their cell, describing the crime in fragments over multiple discussions. According to Flint, Rook had talked about losing control, about wrapping something. Flint could not recall if Rook specified what, around Ember's neck, about panicking afterward and leaving the building before anyone could see him in a compromised state. Flint said Rook never articulated a clear motive, only that Ember had pushed him too far with the grievance and public complaints. Prosecutor Slate recognized the evidentiary value immediately. Flint's testimony could transform a circumstantial case into one with direct evidence of guilt. It would corroborate motive and intent where physical evidence remained ambiguous. Slate documented Flint's statement in a formal proffer, disclosed it to the defense as required, and began preparing Flint for trial testimony. Flint, however, had substantial incentive to cooperate. He faced a sentencing range of 8 to 15 years for his burglary convictions, with enhancements for prior offenses. Cooperation with law enforcement carried tangible benefits: sentence reductions, favorable housing assignments, prosecutor recommendations to the parole board. Defense counsel at trial, a public defender named Marrow, carrying a caseload of over 60 active cases, raised these incentives during cross-examination, pointing out that Flint stood to gain considerably from providing helpful testimony. But Flint's narrative held together under questioning. He recounted specific phrases, described details about the breakroom layout that matched crime scene photographs, provided timestamps for when Rook allegedly made these admissions. Slate argued persuasively that only someone who had actually been present at the crime scene or someone told by the perpetrator could know such granular details. The jury would ultimately find Flint's account credible enough to satisfy the reasonable doubt standard. The trial in Granite County Superior Court convened in November 1995, 10 months after Ember's death. Judge Keystone, appointed to the bench 3 years earlier after a career as a prosecutor, presided over 8 days of testimony and argument. The courtroom was packed throughout, with Ember's family occupying the front row of the gallery, reporters filling the remaining seats, overflow crowds gathering in the hallway outside. Prosecutor Slate built the case methodically, calling witnesses in an order designed to construct a narrative arc. He opened with Dr. Cove, the medical examiner, who testified about the cause of death, asphyxiation due to ligature strangulation, combined with blunt force trauma that had rendered Ember disoriented and vulnerable. Dr. Cove described the ligature marks in clinical detail: depth, width, angle, all suggesting a sustained application of force over 1 to 2 minutes. The jury sat transfixed as Dr. Cove explained how consciousness would have faded, how death would have followed within minutes. The testimony was graphic, deliberate, designed to imprint the brutality of the act. Slate then called Detective Harbour, who walked the jury through the investigation: the crime scene, the canvass of employees, the identification of Rook as a person of interest. Harbour testified that Rook's account of a brief, cordial conversation conflicted with witness observations, that Rook had no alibi for the critical time window, that Rook's demeanor during questioning had been unusually detached. Slate introduced photographs of the breakroom, the blood spatter, Ember's injuries, each image projected on a screen where the jury could study them. Forensic analyst Juniper testified next, describing the fingerprint evidence. She explained the process of lifting latent prints, comparing ridge patterns, assigning probability of match. She acknowledged under gentle questioning from Slate that she could not determine precisely when Rook's prints had been deposited on the thermos, but she emphasized that the prints were fresh, unsmudged, consistent with recent handling. Defense attorney Marrow objected to the characterization of fresh as speculative, but Judge Keystone allowed the testimony with an instruction to the jury that freshness could not be scientifically measured from a fingerprint alone. Cinder took the stand on the 4th day of trial. By this point, nearly a year after the initial event, his memory had calcified into certainty. He recounted the argument in vivid detail: the raised voices, the pointing finger, Rook's aggressive posture, Ember's visible distress. Under direct examination by Slate, Cinder testified that he had heard Rook say, "You're going to regret this," delivered in a tone that Cinder described as threatening. He said the encounter had lasted perhaps 45 seconds, that he had considered intervening but decided it was not his place, that he had moved on to his maintenance task and thought nothing more of it until detectives contacted him days later. Defense attorney Marrow's cross-examination focused on the evolution of Cinder's statements. Marrow introduced the initial police report, completed 3 days after Ember's death, which made no mention of an argument, no mention of threats, only a passing reference to seeing Rook and Ember talking near the break room. Marrow asked Cinder to explain how his recollection had become so much more detailed over subsequent interviews. Cinder responded that he had initially been in shock, that the magnitude of the event had taken time to process, that speaking with detectives multiple times had helped him recall details he had suppressed or overlooked. Marrow pressed, had detectives suggested what he might have seen? Cinder denied it. Had they shown him photographs or provided context that shaped his memory? Cinder admitted they had shown photos, but maintained his memory was independent. The exchange was tense but inconclusive. The jury's expression suggested they found Cinder's explanation plausible. Trauma affects memory, and delayed recall is not uncommon. The most damaging testimony came from Flint, the jailhouse informant. Slate called him on day 6 after the forensic and eyewitness evidence had established a framework. Flint, dressed in county-issued coveralls, recounted the alleged confession with theatrical precision. He described late-night conversations in the cell, Rook lying on the upper bunk speaking into the darkness, voice low and halting. Flint quoted Rook as saying he had lost it when Ember confronted him about the grievance, that he had grabbed something. Flint thought Rook said a rag or cord from a cleaning cart and used it to silence her. Flint testified that Rook described wrapping the material around Ember's neck from behind, pulling tight, feeling her struggle, and then go limp. Flint said Rook mentioned panicking, wiping surfaces, leaving through a side door to avoid cameras. The level of detail was extraordinary, and Slate ensured the jury understood its significance. Flint knew facts about the crime scene that had not been publicly disclosed, facts that could only have come from the perpetrator or investigators. Marrow's cross-examination of Flint was aggressive. He established that Flint faced substantial prison time, that cooperation agreements with prosecutors routinely resulted in sentence reductions, that Flint had a documented history of dishonesty, including prior fraud convictions. Marrow asked whether Flint had been promised anything in exchange for his testimony. Flint denied any explicit promises, but acknowledged hoping for favorable treatment. Marrow introduced jail logs showing that Flint had requested multiple meetings with prosecutors in the weeks before agreeing to testify, meetings that suggested negotiation. He asked whether Flint had access to news coverage of the case, whether he could have learned crime scene details from media reports. Flint admitted watching television news in the common area, but insisted his knowledge came from Rook's admissions. The defense case was constrained by limited resources and strategic challenges. Public defender Marrow had few tools to counter the prosecution's narrative. Rook's alibi rested entirely on his own testimony. He left work at 11:12 p.m., drove home through empty streets, arrived at his apartment around 11:35 p.m., and spent the night alone watching television and sleeping. No roommate, no phone calls, no receipts or transactions to corroborate his timeline. Marrow called Rook to the stand, a decision fraught with risk but necessary given the absence of alternative witnesses. Rook testified in a flat, affectless manner that troubled observers. He answered questions directly, without elaboration, his voice rarely rising above a monotone. He described his relationship with Ember as cordial but distant. They worked in proximity but were not friends, had no social contact outside the plant. He acknowledged the overtime grievance, but characterized it as a bureaucratic matter, not a personal conflict. He denied ever arguing with Ember, denied making threats, denied any physical altercation. When Slate cross-examined him about his lack of emotion, his failure to express grief or outrage at being accused, Rook responded that he was shocked and overwhelmed, that he did not know how to perform the emotions others expected. The answer was honest but alienating. Jurors would later tell reporters, through intermediaries and off the record, that his affect disturbed them. They expected someone falsely accused to be indignant, passionate, desperate to prove innocence. They saw reserve, control, detachment. Marrow attempted to challenge the forensic gaps in the state's case. He called an independent forensic consultant, alias Dr. Ledge, who testified that touch DNA technology was advancing rapidly and that testing the biological material from Ember's fingernails and neck could provide definitive identification of the assailant. Dr. Ledge explained that epithelial cells transfer during struggle, that skin cells lodge beneath nails when victims claw at attackers, that such evidence could exclude or implicate suspects with scientific certainty. Marrow argued that the state's failure to conduct this testing left a critical question unanswered. But in 1995, touch DNA was not standard practice, and Dr. Ledge's testimony sounded speculative to jurors unfamiliar with the technology. Slate objected repeatedly, characterizing the testimony as hypothetical and irrelevant to the evidence actually before the court. Judge Keystone sustained most objections, and Dr. Ledge's impact was minimal. Slate's closing argument was masterful. He wove the three pillars, eyewitness, confession, forensics, into a coherent narrative. He acknowledged that no murder weapon had been recovered, that DNA testing had not been conducted, that some details remained uncertain, but he emphasized that guilt need not be proven with absolute certainty, only beyond reasonable doubt. He reminded the jury that Cinder had no motive to lie, that Flint's knowledge of the crime scene was inexplicable unless Rook had confessed, that Rook's own cold demeanor suggested consciousness of guilt. He invoked Ember's family, seated in the front row, and asked the jury to deliver justice. Marrow's closing focused on reasonable doubt. He highlighted the evolving nature of Cinder's testimony, the incentives driving Flint's cooperation, the absence of physical evidence linking Rook to the act of killing. He argued that fingerprints on a shared thermos proved nothing, that a workplace disagreement was not motive for murder, that the state's case rested on speculation and self-interest rather than proof. He urged the jury to demand more than suspicion, more than coincidence. But his argument lacked the emotional resonance of Slate's. The jury deliberated for 19 hours over 3 days. The verdict came on a grey afternoon in late November. The foreperson stood and read the decision. Guilty of murder in the first degree. Rook absorbed the words without visible reaction, hands folded on the defense table, eyes forward. Ember's family wept openly. Reporters filled notebooks. Judge Keystone scheduled sentencing for 2 weeks later. At that hearing, he imposed a sentence of life in prison with the possibility of parole after 25 years, citing the calculated nature of the crime and the need for deterrence. Rook was led from the courtroom in shackles, and the press coverage the following day described him as a monster who had hidden behind a facade of normalcy. If you're drawn to stories where justice takes decades to surface and truth hides in unsealed evidence envelopes, consider subscribing and sharing your thoughts below. These cases demand more than passive consumption. The years inside Granite State Penitentiary moved according to a rhythm entirely foreign to the outside world. Days blurred into weeks, weeks into months, months into years. Rook worked in the prison library, a quiet job that suited his temperament, shelving books, processing requests from inmates, maintaining the catalogue system. He attended mandatory programs, earned certificates in vocational skills he would never use, kept his head down, and avoided conflict. The unspoken rule of prison life was simple: do your time without drawing attention. He reached the 25-year mark in November 2020, eligible for parole consideration. The hearing took place via video link, a pandemic-era accommodation that made the process feel even more sterile and distant. Members of the parole board appeared on a screen, faces framed in small rectangles, voices tinny through the connection. They reviewed his disciplinary record, clean, no infractions, and asked the required questions. Had he reflected on his crime? Did he accept responsibility? Had he shown remorse? Rook answered honestly. He maintained his innocence. He had not killed Ember. He could not accept responsibility for an act he did not commit. He understood that this answer would doom his application, but he could not bring himself to confess falsely for the sake of parole. The board members conferred briefly, their conclusion predictable. The denial letter arrived 3 weeks later, citing failure to demonstrate remorse and acceptance of responsibility. The letter noted that maintaining innocence was incompatible with rehabilitation in the board's assessment. Rook filed the letter with the others, a growing stack that documented repeated denials. He wrote letters to appellate attorneys, to innocence projects, to legal clinics, anyone who might review his case. Most went unanswered or elicited form responses expressing regret that resources did not permit representation. Direct appeal had been exhausted in 1997, with the state appellate court affirming the conviction on procedural grounds and finding no reversible error. Post-conviction relief petitions filed in subsequent years had been denied for lack of new evidence. Marrow, the original public defender, had left criminal practice years earlier, and Rook had no funds to retain private counsel. His family fractured under the weight of time and uncertainty. His sister had visited twice in the first decade, awkward hours in the visiting room where conversation never flowed easily, where her discomfort was palpable. She had believed him initially, had even attended some hearings, but as years passed and appeals failed, doubt crept in. She stopped visiting, stopped writing. His brother sent a single card years ago, no return address. A brief note wishing him well, but making clear that maintaining contact was too painful. Rook understood. He would have done the same, but he clung to one thread, one piece of knowledge that sustained him through the darkest stretches. The evidence still existed. He knew that biological material from Ember's body, the fingernail scrapings, the neck swabs, had been collected and stored. He knew that forensic science was advancing, that DNA testing had become more sensitive, more powerful, capable of developing profiles from trace amounts of cellular material. He read everything he could find in the prison library about post-conviction DNA exoneration, about cases where new testing had overturned decades-old convictions, about statutory reforms allowing inmates to petition for analysis of preserved evidence. In 2018, he came across a legal bulletin describing recent changes to the state's post-conviction DNA testing statute. The law now permitted inmates to file motions requesting forensic analysis of biological evidence if such testing had a reasonable probability of producing material exculpatory results. The standard was not absolute certainty of innocence, only that the evidence could cast doubt on the conviction. Rook drafted a handwritten motion, working slowly over several weeks, citing the statute, describing the stored evidence, arguing that DNA profiles from the fingernail scrapings and ligature swabs could exclude him and identify the actual perpetrator. The motion was grammatically rough, full of misspellings and awkward phrasing, the work of someone without legal training struggling to translate desperation into formal legal language. But it reached the court clerk's office, was stamped and filed, and eventually landed on the desk of an intake coordinator at the State Innocence Clinic, a non-profit law office affiliated with the state university and dedicated to investigating claims of wrongful conviction. Attorney North, a staff attorney at the clinic with 7 years of experience reviewing post-conviction cases, pulled Rook's file on a Tuesday morning in late 2018. She read through the trial transcript, the appellate briefs, the police reports, the forensic logs. Red flags appeared immediately: a jailhouse informant with clear sentencing incentive, an eyewitness whose account evolved dramatically between initial contact and trial testimony, fingerprint evidence that proved only incidental contact, and, most critically, biological evidence that had never been tested. She highlighted the passage in Juniper's evidence log describing epithelial cells beneath Ember's nails and cellular material on the neck swabs. She calculated timelines: 33 years since the crime, 23 years since Rook's direct appeal, 2 decades of advancing DNA technology. North took the case. She filed a notice of representation with the court and began the process of securing authorization for testing. It would not be simple. Prosecutor Slate had retired years earlier, but the district attorney's office assigned a deputy, alias Cross, to oppose the motion. Cross filed a response arguing that the fingerprint evidence and eyewitness testimony had been sufficient for conviction, that DNA results would not necessarily exonerate Rook even if they excluded him. He could have worn gloves. The ligature could have been brought from outside the facility. Multiple perpetrators could have been involved, though no such theory had ever been presented at trial. Cross contended that reopening the case 33 years later would be a waste of resources and unfair to Ember's family, who deserved finality. North countered with case law. She cited precedent establishing that the statute did not require certainty of exoneration, only reasonable probability that testing could produce material evidence. She pointed out that no glove theory had been presented at trial, that the crime scene evidence suggested a single perpetrator, that Rook's exclusion from biological evidence recovered from the victim's body would fundamentally undermine the state's case. She argued that justice had no statute of limitations, that the evidence existed precisely to answer these questions, that denying testing would be denying truth. The motion was argued before Judge Keystone, now in his late 60s, presiding over the same courtroom where he had sentenced Rook 3 decades earlier. The hearing in November 2023 was brief, less than an hour. Cross argued for finality and judicial efficiency. North argued for accuracy and scientific truth. Judge Keystone asked pointed questions. What was the condition of the stored evidence? Had chain of custody been maintained? What was the current state of DNA testing technology? North provided affidavits from Arcadia Lab confirming that the evidence had been properly stored in climate-controlled conditions, that the paper envelopes had been sealed and logged, that modern STR profiling and touch DNA extraction could develop profiles from epithelial cells with high probability of success. Judge Keystone took the matter under advisement and issued a written order 2 weeks later. Motion granted. The biological evidence would be released to Arcadia Lab for DNA analysis, with costs to be borne by the state Innocence Clinic. The order specified that testing would employ current best practices, including multiple extraction attempts if initial efforts failed, and that results would be provided to both defense and prosecution simultaneously. Arcadia Forensic Laboratory received the evidence in January 2024. The sealed envelopes were photographed, opened under sterile conditions, contents documented with meticulous precision. Forensic analyst Juniper, now a senior supervisor at the lab, personally oversaw the process. She had testified at the original trial 29 years earlier, and the case had stayed with her, one of hundreds she had worked but memorable for the questions it left unanswered. The fingernail scrapings, stored in a small paper bindle inside a sealed envelope, contained visible particulate matter, including what appeared to be skin cells, and possibly blood. The swabs from Ember's neck, taken from the area where the ligature had compressed tissue, showed residue consistent with epithelial cell transfer. Juniper assigned the samples to a DNA analyst, alias Reed, who specialized in low copy number and degraded sample extraction. Reed employed a multi-step protocol. First, he used a silica-based column extraction method optimized for trace DNA, separating cellular material from substrate and contaminants. Next, he amplified the genetic material using polymerase chain reaction, targeting 16 STR loci plus amylogenin for sex determination. The amplified product was then subjected to capillary electrophoresis, producing an electropherogram, a graph showing peaks at specific genetic markers. Reed analyzed the data using probabilistic genotyping software, which calculated the statistical weight of the profile and compared it against known reference samples. The results were unambiguous. The fingernail scrapings yielded a complete single-source male profile, with all 16 STR loci producing clear, interpretable peaks. The random match probability, the likelihood that this profile would appear in an unrelated individual, was calculated at 1 in several trillion for the general population. Reed compared the profile against Rook's known reference sample, collected during the original investigation and stored in the case file. The profiles did not match. At 11 of the 16 loci, Rook's profile showed alleles that were completely absent from the evidence profile. The exclusion was absolute and definitive. The neck swabs produced a more complex result, a DNA mixture indicating contributions from at least 2 individuals. Mixture interpretation is challenging, requiring sophisticated statistical analysis to deconvolute overlapping profiles. Reed applied probabilistic genotyping algorithms, which calculated the likelihood ratio for various donor scenarios. The major contributor, the profile represented by the highest peak heights across most loci, matched the single-source profile from the fingernail scrapings. The minor contributor, present at much lower levels, matched Ember's own reference profile, likely from her own epithelial cells. Rook's profile was not detected in the mixture. Again, the exclusion was clear. Juniper reviewed Reed's work, verified the methodology, checked the calculations. She drafted a formal laboratory report certifying the findings and included an interpretation section. The DNA profile obtained from fingernail scrapings and the major contributor profile from neck swabs exclude Rook as the source. The profile is consistent with transfer during physical struggle and strangulation. No match to Rook was observed at any tested locus. The report was released simultaneously to North and the District Attorney's Office in April 2024. North read it 3 times in her office, then walked to the small conference room where she could be alone and allowed herself a moment of quiet fury at the 30 years that had been stolen. Then she called the prison and arranged a legal visit. She met Rook in the attorney consultation room, a cinder-block space with a metal table bolted to the floor and fluorescent lights that buzzed. She placed the report on the table between them and explained each section, the methodology, the statistics, the exclusion. Rook listened without interrupting, eyes moving across the technical language, hands flat on the table. When she finished, he asked a single question. "Does this mean they have to let me out?" North explained that it was not automatic, that they would need to file a motion for a new trial based on newly discovered evidence, that the state could oppose, that Judge Keystone would need to rule. But she also said that the DNA evidence was as strong as it gets, that exclusion from biological evidence recovered from the victim's body during a violent struggle was nearly impossible to explain away, that she was confident. She began preparing the legal filings immediately. The motion for a new trial was supported by the DNA report, an affidavit from Juniper explaining the science, and a memorandum of law arguing that the new evidence satisfied the standard for relief. It was material, it was not available at the time of trial, and it would probably produce a different result if a new trial were held. North argued that the DNA evidence directly contradicted the prosecution's theory that Rook had killed Ember in a physical confrontation, that it established the presence of an unknown perpetrator, and that no reasonable jury could convict in the face of such evidence. But North also pursued another angle. She located Cinder, the eyewitness, through public record searches. He was living in a neighboring state, retired from maintenance work, 71 years old. She called him on a Thursday evening in May. introducing herself and explaining that she represented Rook in a post-conviction matter. Cinder was initially wary, defensive, but over the course of 2 phone conversations, his certainty began to erode. North asked him to recall the night of the crime, the conversation he claimed to have witnessed. She asked whether detectives had shown him photos, whether they had suggested what he might have seen, whether the passage of time might have affected his memory. Cinder admitted that the interviews with Detective Harbour had been intense, that he had felt pressure to help, to provide useful information. He acknowledged that his initial written statement, completed 3 days after Ember's death, mentioned only seeing Rook and Ember talking, with no reference to an argument or threats. He said that subsequent interviews had involved detectives asking leading questions. Did he seem angry? Did she seem scared? What exactly did you hear? And that his answers had evolved in response to those prompts. North asked whether he could still say, with the certainty he had expressed at trial, that he witnessed a heated argument. There was a long pause. Cinder said he wasn't sure anymore, that the memory felt less like something he had directly observed and more like something he had reconstructed from fragments and suggestions. North asked if he would be willing to provide a sworn affidavit, clarifying his testimony, acknowledging the influence of investigative pressure on his recollection. Cinder hesitated for 2 days, then agreed. The affidavit was executed in front of a notary in Cinder's home state. It stated, "I testified at trial that I witnessed an argument between Rook and Ember. Upon reflection and after many years, I can no longer state with confidence that I observed such an argument. My trial testimony was influenced by repeated questioning from investigators who suggested what I might have seen. My initial statement more accurately reflects my uncertain recollection. I saw them talking, but I cannot now say that the interaction was hostile or that threats were made." North included the affidavit in an amended motion filed in June 2024. The state's case was collapsing. The DNA excluded Rook, the eyewitness had recanted, and only the jailhouse informant's testimony remained. But Flint had died in 2017, so direct recantation was impossible. North included records showing that Flint had received a sentence reduction shortly after Rook's conviction, a benefit that had been disclosed at trial but downplayed by the prosecution. She argued that the confluence of incentivized testimony, discredited eyewitness evidence, and definitive forensic exclusion rendered the conviction fundamentally unreliable. The district attorney's office, now led by a different elected official than the one who had overseen the original prosecution, faced a decision. Deputy Cross filed an initial opposition, but the tone was notably subdued. Cross acknowledged the strength of the DNA evidence, but suggested that theoretical possibilities remained. Perhaps Rook had been present, but not the person who strangled Ember. Perhaps an accomplice had acted while Rook facilitated. But these theories had never been presented at trial, were not supported by any evidence, and contradicted the state's own original narrative of a lone killer acting in rage. Within weeks, the district attorney issued a statement indicating that the office would not vigorously oppose the motion for a new trial, that the DNA evidence raised substantial questions about the reliability of the conviction, and that the interests of justice required a full evidentiary hearing. The statement stopped short of conceding error, but signaled that the state would not fight to preserve the conviction at all costs. The evidentiary hearing was scheduled for September 2024. Courtroom 4C filled early on the morning of the first session, journalists claiming seats, law students from the university clinic observing, 2 members of Ember's extended family who had followed the case for decades, sitting quietly in the back row. Rook was transported from the prison in the early hours, processed through courthouse security, and seated at the defense table next to North. He wore civilian clothing provided by the clinic, khaki pants, a button-down shirt, but the clothes hung loosely on a frame shaped by decades of institutional food and limited movement. Judge Keystone entered at 9 a.m. sharp. He was 70 now, white-haired, moving more slowly than he had 3 decades earlier, but his voice retained authority. He outlined the scope of the hearing. The court would receive testimony regarding the DNA evidence, evaluate the eyewitness recantation, and determine whether the new evidence warranted vacating the conviction and ordering a new trial or dismissing charges outright. North called Juniper first. The forensic analyst walked to the witness stand with the practiced ease of someone who had testified hundreds of times. She was sworn in, and North took her through the DNA analysis step by step. Juniper explained touch DNA transfer, described the extraction protocol, detailed the STR profiling methodology. She displayed enlarged copies of the electropherograms on a screen, pointing to the peaks that represented genetic markers, showing the jury how the evidence profile and Rook's reference profile diverged at multiple loci. "Could this profile have come from Mr. Rook?" North asked. "No," Juniper replied. "The exclusion is definitive. The profiles do not match at 11 of 16 loci. The probability that this is a coincidental exclusion is effectively 0. Cross, the deputy prosecutor, cross-examined carefully. He asked about the possibility of contamination during the 29 years of storage. Juniper walked through the chain of custody, sealed envelopes, climate-controlled locker, documented access log showing only 3 instances of retrieval for inventory audits. No unauthorized handling. She explained that contamination typically introduces modern DNA profiles, lab personnel, recent handlers, whereas the evidence profile was consistent with degraded cellular material from the time of the crime. Cross asked whether the DNA could have transferred innocently before the crime occurred. Juniper acknowledged that secondary transfer is theoretically possible, but pointed to the location of the evidence, beneath the victim's fingernails, where material lodges during defensive clawing, and on neck tissue compressed by a ligature. She testified that the context made innocent transfer highly unlikely. "What about laboratory error?" Cross asked. "Could the profile have been misread?" Juniper explained the quality control protocols. Multiple analysts reviewing data, software validation, blind proficiency testing. She stated that the profile had been confirmed through independent re-extraction and re-amplification, producing consistent results. Error was not a credible explanation. Cross's cross-examination was thorough, but lacked the aggressive edge that might have characterized a prosecution determined to preserve a conviction. It felt more like due diligence, ensuring that all questions were asked, all possibilities explored, but without genuine belief that the DNA evidence could be discredited. North next introduced Cinder's affidavit. Cross objected on hearsay grounds, arguing that the affidavit was an out-of-court statement offered for its truth and that Cinder should be compelled to appear for cross-examination. North countered that the affidavit fell within the exception for statements against interest. Cinder's affidavit undermined his own prior testimony and subjected him to potential perjury liability, making it inherently reliable. Judge Keystone admitted the affidavit, though he noted that he would consider the absence of live testimony in weighing its credibility. Cross called Detective Harbour as a rebuttal witness. Harbour, now 73 and long retired, testified that his investigation had been thorough and professional, that Cinder's statements had been voluntary, that he had not fed details to the witness. He maintained that Flint's confession had been independently corroborated by crime scene knowledge. But on cross-examination, North walked him methodically through the timeline of Cinder's evolving statements, reading verbatim from the initial report, "Saw them talking," and contrasting it with the trial testimony, "Heated argument, threatening language." She asked whether it was standard practice to interview witnesses multiple times, allowing narratives to develop over weeks. Harbour defended the practice as thorough investigation, but the pattern was clear. Each subsequent interview had added detail, texture, certainty. North asked whether Harbour had documented the specific questions he asked Cinder during these interviews. He admitted that detailed interview notes were not always preserved, that he relied on summaries. The implication hung in the courtroom. Cinder's memory had been shaped, consciously or not, by the investigative process. North's closing argument was restrained but devastating. She emphasized that the state's original case had rested on three pillars: eyewitness testimony now recanted, jailhouse informant testimony given by a dead man with documented incentive, and fingerprint evidence that proved only incidental contact. Against this stood DNA evidence excluding Rook from biological material recovered from the victim's body during a violent struggle. She cited Schlupp Vixu. Dello, the Supreme Court case establishing that new evidence of actual innocence can overcome procedural bars, and state precedent holding that DNA exclusions from crime scene evidence create substantial doubt about guilt. She argued that no reasonable jury, presented with the totality of evidence available today, would convict Rook. The DNA proved that someone else killed Ember, someone whose genetic profile was not in any database, someone who had never been identified or investigated. Rook had spent 30 years in prison for a crime the science now proved he did not commit. Cross's closing was brief and notably lacking in passion. He acknowledged the power of the DNA evidence, suggested that theoretical questions remained about the precise sequence of events, but conceded that the new evidence substantially undermines confidence in the verdict. He did not explicitly ask the court to preserve the conviction, instead framing the issue as one for judicial discretion. Judge Keystone took the matter under advisement. The courtroom cleared slowly, spectators lingering in hushed conversations. Rook returned to the holding area to await transport back to the prison. 3 weeks passed. Then, on a Friday afternoon in early October, the court issued a written order. The ruling was detailed, methodical, and unequivocal. Judge Keystone found that the DNA evidence was newly discovered, material, and credible. He found that Cinder's recantation was supported by objective review of the investigative record and undermined a critical component of the state's case. He found that the jailhouse informant's testimony, viewed in light of the DNA exclusion, could not support the verdict. He wrote, "The integrity of this conviction cannot withstand the weight of the evidence now before the court. The DNA profile recovered from the victim's body excludes the defendant at multiple loci and identifies an unknown perpetrator. No theory consistent with the defendant's guilt adequately explains this evidence." The order vacated Rook's conviction and dismissed the charges with prejudice, meaning the state could not retry him. Judge Keystone noted that while he could order a new trial, the passage of time, the death of key witnesses, and the strength of the exculpatory evidence made retrial neither feasible nor just. He concluded, "The defendant has served 30 years for a crime the evidence now shows he did not commit. Further detention would compound injustice rather than serve it." Rook was processed out of Granite State Penitentiary on a Monday morning, the first week of October 2024. The release procedure was bureaucratic and slow. Fingerprints, photographs, return of property, signatures on multiple forms. He left through the main gate carrying a small duffel bag containing legal papers, a few books, and a photograph of his sister taken decades ago, before the estrangement. He walked through the security gates into morning sunlight, the kind of light that felt foreign after 3 decades of fluorescent corridors and barred windows. Attorney North met him in the parking lot. They stood in silence for a moment, neither quite knowing what to say. Then she drove him to a halfway house in Riverbend, where the Innocence Clinic had arranged temporary housing while he navigated re-entry. Compensation proved more complicated than exoneration. The state had a wrongful conviction compensation statute allowing exonerees to claim monetary relief. but the process required extensive documentation, legislative review, and approval. North filed the petition, calculating Rook's losses at 30 years of wages, lost Social Security contributions, retirement savings he never accumulated, and the immeasurable cost of decades stolen. The figure exceeded $2 million. The state's compensation board offered a fraction, citing budgetary constraints and statutory caps. Negotiations dragged on for months. Rook's criminal record was expunged, but the practical erasure of 3 decades was impossible. Employers asked about employment gaps. Landlords ran background checks that surfaced old news articles calling him a monster. Rook found part-time work stocking shelves at a hardware store, a quiet job that required no explanations, no prolonged interactions. The manager, aware of his story, asked no questions. Ember's family issued a brief statement through their attorney, expressing continued grief that the case remained unresolved and asking law enforcement to pursue the unknown DNA profile. Granite County Sheriff's Office reopened the investigation, uploading the profile to genealogical databases and initiating familial searches. As of late 2025, no match had been identified. The person who killed Ember remained unknown. North reflected on the case in interviews with legal journals and criminal justice reform organizations. She emphasized that Rook's exoneration illustrated predictable systemic vulnerabilities, investigative pressure to close high-profile cases, eyewitness memory malleability, jailhouse informant incentives, underfunded forensic labs, and the psychological weight juries place on witness certainty. She advocated for mandatory recording of all custodial interrogations, open file discovery requirements, corroboration rules for informant testimony, and statutory guarantees of post-conviction DNA access. Rook himself declined media requests. He attended one exoneration event organized by the Innocence Clinic, sitting quietly in the back while other exonerees shared their experiences. Afterward, he thanked North and left without speaking to reporters. On a cold morning in November 2025, Rook sat at a small kitchen table in a subsidized apartment, the kind with thin walls and a view of a parking lot. The apartment was his first permanent residence in 30 years. He made coffee in a second-hand percolator, the sound filling the silence. On the table lay the evidence custody log from the original case, a document North had obtained and copied for him. He traced his finger down the entries: thermos, swabs, scrapings, photographs. Each item a fragment of a life interrupted, a system that had failed, and a truth that had waited 3 decades to surface. Outside, freight trains rolled through Riverbend's industrial quarter, the same rhythm that had filled the background on the night Ember died, the night Rook clocked out and drove home, unaware that within hours his life would be consumed by machinery that would grind forward for 30 years before science finally stopped it. The DNA profile remained in databases, a question without an answer, a reminder that justice and truth are not always synonymous, that exoneration restores freedom but cannot restore time. Rook set the log aside and drank his coffee. The apartment was quiet, the kind of quiet that settles after decades of institutional noise. He did not know what would come next, only that it was his to decide. The system had taken 30 years. Forensics had returned them, or what fragments remained. If stories like this resonate with you, share your thoughts below and subscribe. Wrongful convictions expose the fragility of certainty, and understanding how systems fail is the first step toward building ones that don't.